at 10 a.m. I'm going to ask Commissioner Russell to lead us in the pledges, national and state. I will now invite a motion for excused absences for Commissioner Hargrave and Commissioner Stevens.
Move that we excuse the absences of Commissioner Hargraves and Stevens.
Second.
Motion was made by Commissioner Leonard, seconded by Commissioner Turner. All in favor?
Aye.
Aye.
All opposed? Any abstain? Motion carries. Couple remarks I'd like to make. Commissioner Stevens. Okay.
You want a do-over?
Let the record show Commissioner Stevens is here. I want to just make a couple remarks from the chair. First of all, I want to thank everybody that is attending this meeting, whether it be staff, outside providers, associations, or whatever. We thank you for your engagement, and we invite your engagement. We also invite your comments. I'd like to give a shout out to staff and all the commissioners. Yesterday we had a workshop, and the workshop was open to the public, and we went over several issues. We talked about things that have been done, things that need to be done. I think we came up with some really great ideas how to move this agency forward. I think it gave all the commissioners and the staff an opportunity for transparency to talk and discuss issues that we might run into. I'd also like to mention a little bit about Arello. Arello's conference was in November, or October, I guess. I don't know when it was. September, a couple months ago. Yeah, I don't even know what today is, okay? And I need to say Arello has some huge benefits and resources for this commission and this agency, and also the board. At the same times, with the benefits and resources, I did realize a lot of the stuff that happens at Arello, our talented staff at the agency can certainly take us through the training that I went through at Arello, and they can bring back some of the information on some of the issues that are going across the nation and bring back to us as commissioners. So even though it was a great meeting, there are certain parts of that I think we can do internally and really focus more on this agency and moving this agency forward. I also want to commend staff for their efforts and accomplishments and completed tasks on the sunset. They've done an incredible job taking that list of concerns and checking them off. We also completed a survey of our membership. I think we had about 2,500 responses. We're going to take that feedback, also looking at listening tours next year to bring concerns and comments and just overall issues that our shareholders and licensees and members of the public might want to bring forward. And the last thing I want to mention is I want to congratulate Sarah Oates for her appointment to the Appraisal Board. We've had a great opportunity in the last 2 weeks or 3 weeks for the Appraisal Board and the Commission to work together. And I think it has certainly made us a stronger agency, even though it is theoretically two different entities. We are one. And congratulations to Sarah and her entire board for certainly working with us to make this agency better. Agenda item number 4, appointments to the Education Standards Advisory Committee. I am appointing Rick Albers as a public member, replacing Marcela Gomez Falcon, and Candy Cook He is appointed in the open educator position, replacing Felicia Peters. Rob Cook and Sarah Norman, both brokers, will be reappointed. Agenda item number 5, we will have a committee to review applicants for the Texas Real Estate Inspector Committee. I have asked the current chair, Lee Warren, of the Inspector Committee to sit on that. There needs to be a commission member, and since I'm the liaison for the inspectors, I will take that position. And I've asked Jeffrey Michael, an inspector from the El Paso area, to also sit on that. And those are the first 5 agenda items. I will now go to agenda item number 6, staff reports, and we will start with the Executive Director, Doug Olmixon.
Good morning, Mr. Chair and members. Your staff, it is your staff's pleasure to host and support you for your regular quarterly business meeting, where the work of making decisions that direct the policies of this agency occurs. It is our task to implement those directives and to manage the daily operations of this fine organization. We're especially grateful for yesterday's extended workshop, where all those in attendance received the annual refresher training, and we discussed a significant issues with especially on the progress of our agency's performance this year compared to the prior years. That year-over-year annual reporting continues to show significant progress that the agency is making and a slight slowing of our overall growth as an industry. We also explored. You asked us, and we provided some discussion and exploration of the complaint handling process, and especially your role in the resolution of those contested cases. We set expectations going forward with a draft response to the governor's letter that had requested of all agencies the removing of unnecessary barriers to licensure. And we established some priorities for strategic planning for next year. So we look forward to strengthening this approach as we move into 2020 with renewed energy, renewed vision, and renewed leadership. Since we last met in August, your staff has been extraordinarily busy implementing the continued improvements in online self-service tools and overall advancements in customer service, which you will hear about from the Deputy Executive Director and other directors in their staff reports today. I also wanted to thank and just acknowledge the Chair, the Deputy Executive Director, our General Counsel, and I, who all attended Rello's annual meeting together, where we also had the privilege of celebrating the announcement that TREC's Chief Investigator, Roy Minton, was recognized as Rello's Investigator of the Year for 2019. So please help me congratulate Roy. That is that's a global recognition of the hard work that goes into doing some really fine investigative work. As you may be aware, we have prioritized over the last 8 years making sure that every one of our investigators goes through the Rello investigator training, certified real estate investigator training, and that has really paid dividends for us. They do an enormous amount of work of very high quality. So your staff has also focused on ensuring that every detail of the sunset and legislative requirements and requests have been completed or are being fully implemented. On your agenda today are several items which, if adopted by you, will complete that process, including significant fee eliminations, simplifications, and reductions proposed in August that, if adopted today, will become effective in January. And speaking of January, we're also on track to implement the FBI and DPS wrap-back process, which further simplifies the process of criminal history checks for all of our license holders and will save every license holder another $28.25 at each future license renewal. This implementation of this process, I think, is the very definition of a win-win. It simplifies processes for us and reduces costs to our license holders. As we rapidly approach the holiday season, your staff wishes you all the very best. And I'm happy to answer any questions, or I will turn it over to the rest of the directors.
Any questions? Okay, thank you very much. Deputy Executive Director Tony Sligel.
Good morning, Chair, Commissioners. Tony Sligel, Deputy Executive Director of the Commission. I am going to give just a very brief, sort of high-level summation of the customer service report that I sent out to all of you at the beginning of the month, just to touch on some highlights for the record. As you know, from what I sent out, we handled a little over 18,000 calls in October, and we had for the first time we've had a sustained hold time of under 2 minutes for an entire quarter of a calendar year, which is a very, very good improvement. Those 18,000 calls were 10% higher than the calls we received in September. And even with that, the hold time in October was lower than it was the previous month. Slightly, but it was lower. Before I came down, I always like to just give you a snapshot of where we are for the month so far. And as of this morning, we are under a minute for the month and for our hold time, and just under a 3% abandonment rate. So this month is trending very well. To be fair, November's usually a slow month, but even so, it's still nice to be up here and give you good news. Just to break things down a bit, of the 18,000 calls, about 16,400 of them were TREC-related calls, and the contact center was able to handle 94% of the calls that came in through the TREC line, and 96% of those calls they handled at the first time. So someone called, they got a person. We are continuing to look at ways to globally approach the customer service issues, and so one of the major IT projects we have that we're hoping to wrap up by the end of the year, if not sooner, is the document upload process, which will allow people to upload their documents when they apply. Right now they have to email them. It puts a lag in the application process time because of that. This will shorten that time up and increase the hopefully the turnaround in us issuing applications. I'm happy to answer any questions if you have any. I would just real quick like to say for the record that this is a team effort. I stand up here, I get to tell you the good news, but this is the division directors, Robert Hood, Denise Sample. They're the ones working on the licensing and the contact center and getting all of that working the way it needs to. So I get the honor of standing up here and presenting the numbers, but they're the ones giving me the ability to do that. So
Just kudos. That's 4 months in a row you've been under 3 minutes, and 2 months in a row under 2 minutes, with a call still averaging over 17,000 calls a month. So kudos for not only hitting it 1 month, but maintaining it for what I would call a quarter.
yes, sir.
Okay, so congratulations to you and the staff for taking care of that. Any other questions for?
And I might add, Tony, since I know I have been especially critical of our hold time. I don't know if you remember, sometime maybe, this is right after Mr. Hood started. And I caught the two of you out by the elevators. I think Christine might have been there, and I said to Robert, I said, this is your chance to be a hero. You did it, so congratulations. But I'd like to see us work on that email time.
Sir.
2 days. You know, most millennials would prefer to email or text over call. And of course, they want an answer like that. So I'd like that. I want us to stay under a minute on the telephone, and on the email, I'd like to set a goal of all of our emails being within 1 business day.
We will work towards that.
Okay.
Yes, sir.
Good deal.
Thank you.
Thank you.
Anything else?
Okay, thank you.
Thank you.
Now, let's go ahead and invite the hero, Robert Hood, Reception and Communication Services Director. Follow that.
I was waiting for you.
Good morning, Mr. Chair and Commissioners. Robert Hood, Director of Reception and Communication Services Division. Before I start on the status of RCS, I would like to introduce the newest members of our team. Shamara McFarland, Sarah Connolly, and Mandy Garrick. Would you please stand? Thank you. Together, they bring over 20 years of customer service experience, and since their start date of September 1st, they have averaged about 30 calls per day and assisting with our emails. Their personalities, their professionalism, and their eagerness to provide great customer service makes them a great fit to our team. Please help me again welcome Shamira, Sarah, and Mandy. The RCS report that was included in your materials, we're reporting on the first month of the fiscal year, which is September 2019. The report just shows the stats from just the month of September, but going forward, we will include a rolling 12 months, so you'll be able to compare the previous months to the report as well. September phone calls were consistent with the previous months. Hold times were less than 2 minutes as reported earlier, and the abandoned call rate was around 5%. Our email volume was consistent with previous months, and all emails were handled within our 2 business day requirement, and we will be working on that as well, Mr. Leonard. The RCS Customer Satisfaction Survey, the results from September indicated excellent ratings in the telephone and email experience for our customers. An overwhelming 95% of those that completed the survey rated their experience with our customer service representatives as excellent. This will conclude the RCS report. I will be happy to answer any questions you may have.
Any questions?
And I think that high rating of their experience has been like 3 months in a row.
Yes, 3 months, yes.
Again, kudos.
Thank you. Thank you.
Okay. Yes, Commissioner.
I also like to thank Mr. Olmikson because this occurred during his leadership, and I appreciate all the effort that has been done as an agency to get where we are right now. So thank you.
I agree. All right, thank you. Jennifer Wheeler, Education and Examination Services Director.
I'll just step up for a minute. A little bit different today. We reviewed the EE1 report yesterday, which was the 2018-2019 fiscal comparison of exam stats, and that's part of the workshop, but it's not part of the quarterly meeting. So next go around, you'll have some new reports to look at.
Very good.
Any questions?
Any questions? All right, thank you.
Thank you all.
Denise Sample, Licensing and Registration Services Director.
Good morning, Chair and Commissioners. I'm Denise Sample, Director of Licensing and Registration Services. And before I present my reports, I'd also like to introduce a couple of new members to the team. Crystal Hicks joined the agency on November 1st and comes to us with 7 years of experience from the Texas Department of Public Safety, reviewing complex license applications and supporting documents. Tiffany Johnson joined the agency yesterday and comes to us from the Texas Department of Family and Protective Services with 10 years of experience reviewing applications and supporting documents for compliance. Please join me in welcoming Crystal and Tiffany to the team. So the first report I'd like to direct your attention to is the L1 report, which is a fiscal year-to-date comparison of applications received and renewals issued as of September 2019. We continue to see an increase in the number of applications for broker and sales agent licenses, as well as a slight increase in inspector applications for this reporting period. The next report is the L2 report, which is a 13-month comparison of the total number of license holders and shows a continued increase in the overall total of license holders, generally across all the license types. And I'm happy to, pardon me, the next report is just the graphical representation of the L2. And I'm happy to answer any questions about those reports. Yeah.
Mr. Turner.
We covered this in our workshop yesterday, but I want to make sure that we mention it in our public meeting. It's my understanding that we are working on tracking some additional data and putting together an additional report that's going to be able to tell the commission what the average wait time is for licensees who are applying for a license from the application to actual production of that license. Is that right?
Well, what we're narrowing down, the figure that we're looking to start presenting regularly is the average number of days it takes us to process an application. So this way we can discount any time when the applicant is waiting to pass the exam or clear the fingerprint-based background check, or even any time that it takes the applicant to respond to our request for additional information. We want to narrow that to produce the average number of days it takes us to reply to an applicant.
Right, so you eliminate things that the applicant may be causing or delay that they may be causing,
Right.
and just look at our side of things. But we are going to start tracking that and
Yes.
providing that information to the commission.
Yes, we are required to report that information to Sunset by January 1st. You'll have a report prior to that date. We're still fine-tuning how to present that information.
Great, thank you.
Yeah, you're welcome.
Any other questions? Thank you very much.
Thank you.
Mark Moore, TREC Standards and Enforcement Services Director.
Good morning. I've got two new employees. First is Sarah Decker. She should be standing now. She's a she's a lawyer, started in September. She formerly was a county attorney for, I'm doing this from memory, Gillespie and Hockley counties, I believe. Very happy to have her. Yeah. The second new employee, Renitra Johnson, who is probably also standing, she just started on Friday as an investigator. It's a new position just because of the expansion of the number of cases we had. She was formerly an investigator at this I may have to work because the name changed, the Texas Board of Professional Engineers and Land Surveyors. She did that for a number of years and has been in state government since 2001. Also, until last Thursday, she was an active real estate license holder as well, and did some closings, so that's good as well. Yeah. One other thing I'll say immediately following my report, Chair Kestner, Beverly Rabenberg will be giving the annual Timeshare and Residential Service Company report. She's the program manager for those areas and very knowledgeable in both those areas. First report, it's only 1 month of data. We did the year over year last year. On the 1 month, we had a very good start to the fiscal year, that we closed more cases than we opened. Nothing else really stands out on that other than the number of received cases was slightly below average and the number of closed cases was above average. On the next report, the case aging report is good. 98% of the cases are less than 1 year old, and we have only 4 cases that are even over 18 months old. The 2 oldest cases were set for hearing like in December of 2018 and January 2019, and they'll both be heard on your agenda later today as proposals for decision. Final report is the complaint subject categories report. That's the pie chart that sort of graphically represents the broker sales cases we have, sort of the general subject matter of those cases. It's a 13-month average, so it doesn't fluctuate a whole lot. If you want to see detail, it's on the next page, and that kind of gives the raw numbers. You can see sort of the month-to-month fluctuation, but not a huge lot of change in that area. Are there any questions on that report or any of the other 2 reports or the division in general?
I don't have a question, but Mr. Moore, I want to just commend you. Your division continues to shine. I'm impressed in particular with the open case aging report. The wheels of justice turn very slowly as attorneys understand. And we were talking yesterday about, you and I kind of came on board around the same time, and I remember there being significantly more cases that were in that 12 to 18 and 18 to 24 month category, and you do a great job. So
Thank you. We appreciate that.
thank you.
Thank you.
And
One-
as usual, Commissioner Turner takes the words right out of my mouth. Congratulations.
Thank you.
I do have one question, and I brought it up yesterday. Our fitness inquiries. I couldn't get this to come on.
There you are.
Am I on? Yeah. Our fitness inquiries, I was not aware that those were basically the honor system. I'm going to guess that most of the people that request that inquiry are doing so because there's something there and they want to see if we're going to find it or not. If you do the honor system, shouldn't we do a little more thorough background check for that $50?
We could. The weakness of that is that we don't have fingerprints, and most of these are criminal background history checks. And without fingerprints, with a name search, it's you get a lot of false positives, so it's not as good. So what we tell people is we will let you know if you're worried about your DWI from 30 years ago or your possession from 5 years ago or 2 years ago. We'll let you know whether we think you would get a license to clear, we'd consider a probationary license, or that we would deny you. So we try to let them know up front, but you're correct. It's without the fingerprints, there's not a lot more we can do on that.
Okay.
Is there any other information that would be helpful in lieu of fingerprints, and do we ask for it, like social security number, driver's license number, or do we is the process just that they call and say, I've got these priors in my history, is that going to affect my ability to get a license?
That's mostly what we do. We let them know that if they give us full information, we can give them obviously a pretty good estimate of what we're going to do on that. We do name searches at times, even for license holders, if they have unreadable fingerprints. It's just it's not as good a process. You pretty much need fingerprints to get a really good process. So we do get their name and their birth date, and that'll give you pretty sometimes relevant hits depending on how common the name is.
Okay.
Before you step down, you gave me a number last week on the number of licensees in the last 5 years that have never had any type of complaint or enforcement. Would you give us that number? It was just staggering.
Yeah, and I want to clarify one thing. It's formal disciplinary action.
Okay.
So a lot of people get complaints, especially if you represent a lot of agents. You're likely going to get some complaints. But in those that have a valid complaint and we actually reach discipline on, we run a report that looks at the discipline the last 3 years. It's about 99.8% of license holders have no formal discipline in the last 3 years. So it's a pretty tiny number of people that get in trouble.
Great number, all right. Any other questions? Okay, thank you. All right, Beverly Rabenberg? Okay, all right.
Little short for me. Good morning, Chairman Kestner and Commission members. I'm Beverly Rabenberg, an attorney with Standards and Enforcement Services and the program manager for the Timeshare program. In addition to myself, there's one other attorney who handles timeshare as well as a legal assistant. We do that in addition to our broker sales complaints and, as we'll see in a minute, our residential service company responsibilities. If you turn to page 23 in your materials, it's right after Mark's reports. There's a short report on the timeshare program overview. The statute when we regulate timeshares is the Texas Timeshare Act, which is found in the Texas Property Code. It's a consumer protection statute, and there's two big protections in there. There's a right to cancel that isn't typical in most laws. The other thing that's required in the Texas Timeshare Act is a disclosure statement that has a lot of different information in it that's made available to purchasers. The Commission, we register timeshare plans. I think of it like a permit to sell. Registration is required if a developer wants to sell or offer to sell to Texas residents. It covers the sale of direct developer inventory. In looking at the statistics on page 23, as of the end of October, we had 137 registered timeshare plans. Those are the ones that are active and have renewed their registrations. The complaint numbers have increased over 2018, although when I went back and looked at the 2017 numbers, they are reduced. Most of those are for one particular developer, and I really can't say more because those are pending and open cases, and you're the ultimate decision maker, so I can't go into detail, but there has been an uptick, and I'll be working on those cases. There have been no complaints that resulted in disciplinary action since November, my last report in last February. A discipline against a timeshare developer, there's a limited types of things in the Timeshare Act. It's generally things related to deceptive trade practices. So it's if they misrepresent something, if something isn't registered and they're trying to sell it, those are the kinds of things. So, any questions about the timeshare program before I move on?
Go ahead.
Great. Okay, Residential Service Company Program. I also manage that program. And that report is on page 24. Lots of times these people think of these as the home warranties, which is what people generally know them as. This is under the Residential Service Company Act. It's yet another statute that the Commission regulates. Again, it's myself, another attorney, and a legal assistant. We license the companies, we approve their contracts, and we generally approve their rates unless they fall under certain specific requirements. As you can see from the bottom of page 24, we currently have 53 licensed companies. There have been a lot of applications. You can see they doubled. This year, there was 5 in 2017, 5 in fiscal year 2018, and 10 in fiscal 2019. And I went back and looked. In January of 2015, we had a whole 34 companies licensed. We now have 53. So people apparently want to get into this business and comply with the Commission's requirements, and we go ahead and license them. So it's the list of companies are listed on our website, and that's a good place if people want to know if a company's licensed. They can look at that list. The special thing about the Residential Service Company Program that's different from other things the Commission has is we have an ombudsman. This is one person who specially takes residential service company calls, and there's a special phone number that's listed on all the contracts. The other thing that's a little different with residential service companies is that the Commission's complaint information and our address and everything are right on every single contract. So if people have a problem or whatever, they know where to find us, and they can call and talk to our ombudsman. The ombudsman has contacts at the companies and can try and cut through some of the red tape and can get things resolved quickly. We also handle complaints. As you can see, we've had, the complaints have stayed pretty steady. We don't discipline very many, but we do have the ability under the Residential Service Company Act to discipline them. Some people just want to talk to somebody before they file a complaint. Some, the ombudsman is able to help, like on the spot. So, any questions about the Residential Service Company Program?
Commissioner Miller.
I will tell you, until I saw the workshop material, I had forgotten that TREC was the licensing body for these companies. And the reason that you have so many applicants, in my opinion, is because there's been so much distress from the companies that have been in business. I spend more of my time fighting with warranty companies. I never knew I could complain to you. So I'm thrilled. And I can't wait to send all these people that complain to us about them to TREC from now on. So thank you.
Okay.
I've got one question, and I will give you that phone number, Commissioner Miller. I've got it right here, okay? You said there's 53 companies. Is that 53, I'm going to use, I should probably know this, is that 53 mother companies with other companies underneath them? Or is it 50? So if I do a name search on TREC's website, that should show up not as a subsidiary whatever of ABC.
You have to look them up on the the separate list. You can't actually do a name search
Right.
with the sales agents and broker list. But there are 53 separate companies, all licensed by the commission.
So if I do not see ABC Home Warranty and I call them, they say, well, we're really part of XYZ, ABC should be listed.
That's there are some companies that sell contracts in affiliation with other companies. Some of them have DBAs. We do list the DBAs on the website. Some of them use a marketing name. And unfortunately, you pretty much have to call us and we can tell you whether the parent or the company issuing the contract is licensed.
Okay.
But the contracts themselves, even if there is an affiliation, the name of the license holder should be on the contract, so it's clear who's ultimately responsible for the contract and for what's going on with it.
Okay, very good. Any other questions? Yes, Commissioner Turner.
Across the 53 companies, how are the complaints spread across those companies? Do we have any problem children, or is it relatively even? And if we have any problem children, are we doing anything about them?
I understand there's one company we do have a number of complaints on, and we are working, I understand, on a disciplinary case. There's, I can't say a whole lot more than that, but for the most part, most of them take care of business and take care of the consumers, and we don't see that many complaints.
Commissioner Stevens.
Would you please describe the complaints that we have, just generally?
Many cases, most of them are the people think something should be covered, and the company says it isn't. A lot of times you have to read the contract, because this is a contract. The law doesn't say everything has to be covered. And that's one reason the ombudsman is helpful, is not that we know all of the contracts, but lots of times it's the contract holder thinks something's covered and it isn't. Sometimes the company, depends on what the tech tells them, depends on, the customer service people, and sometimes we can work something out. But it's generally coverage issues.
Okay.
I have one.
Commissioner Miller and then Commissioner Williams.
One thing I might suggest is that the brokers are ending up handling most of the problems before y'all get to them. Or I guess I resemble that remark. The other question is, who is the ombudsman an employee of TREC?
Yes. Yeah, that's one of our legal assistants is the ombudsman.
That's
an
fantastic
TREC employee.
When you have one entity that's that you're getting several complaints from, how do you help resolve those?
The commission, we investigate the complaints. We get a written response from the companies, and we have to look at it and decide if there's anything to the complaint that generally it's coverage. We just have to look at it and decide the company should be covering something and they're not.
So I think what I heard you say is you really don't have a solution.
Not to under the Residential Service Company Act, that's a part of regulation. We can license and discipline them. We can take away in their case, their license. But actually ordering them to fix things, kind of like ordering a license holder to do something, that generally isn't within our authority. So that they may still have to go and take legal action and sue the company if they want, for example, monetary relief. That's just the nature of regulation.
Thank you.
Okay, thank you.
Great, thank you.
Next up is Steve Rapp, Information Technology Services Director. While he's approaching the podium, I am going back to agenda item number 1 and let the public know if you would like to make a comment, there is a slip out by the front door that you can fill out and bring up here, and we will let you make a comment. Okay. Steve, welcome.
Welcome, Mr. Commissioner, members of the Commission. Before I present the ITS report, I would like to make some introductions. We have a promotion and 3 new members to the ITS team. If they could all stand, please. See, is that better, Christine? Thank you. She's always got my back. I'm sorry? Yeah. Can you not hear me? Okay. All right. It's always funny when the IT guy has issues, technical issues, isn't it? So, presenting to you today, Dionisio Jackson has been with the agency since 2012. She started as one of our imaging technicians. A couple years ago, she showed some interest in assisting on the help desk. We started training her then. So when we had a vacancy, it was really a no-brainer as to who should step into that, and she has certainly hit the ground running. Beverly Archer fills the position in the back there, Beverly, that Dionisio vacated in the imaging technician. Beverly comes to us with a broad range of experience, most of which was with the Travis County, let's see if I can get this right, Travis County in the criminal court system. Her most recent role there was criminal supervisor over the criminal division for Precinct 2, and we felt that made her a perfect addition for the IT team. Tony Chirian filled a new systems analyst role. He's going to be on the front lines with Dionisio on the help desk. Tony comes to us with a broad range of IT experience in both the private and public sector. He has served the state very well. Some of his other service has been with the State Library, the Dental Board, Health Professions Council, the Bullock Museum, Parks and Wildlife, and UT Austin, and also Texas State University. And last but not least, Tom Perdue filled a new role on our Versus support team. As you well know, Versus is our licensing system. We have experienced some growth and needed some help there as well. Tom comes to us with almost 20 years of experience with the Versa licensing system. He gained that at the Florida Department of Business and Professional Regulation, over at the Texas Department of Licensing and Regulation, and he actually also worked for Versa for about a year and a half. So please help me congratulate Dionisio and welcome the other 3 members to our team. Okay, onto the I-1 report. As you recall, this is a quarterly report that shows the percentage of our applications and renewals and transactions that occur online. Looking at the report, you can see that the initial apps, renewals, and the sponsorship transactions utilization is pretty consistent with what we've seen in previous months and over the past year as well. We do, however, see about a 25% increase in web traffic, which is always good to hear. As you know, that helps keep calls and mail down the more they come to our site. The I-2 report on the next page is simply a graphical representation of the previous report, and happy to answer any questions you may have.
Any questions?
All right, thank you very much.
Okay, thank you very much. Priscilla Papo, Staff Support and Services Director. Priscilla?
Good morning. Priscilla Papo, the Director of Staff and Support Services. So glad to see y'all again this morning. I'd like to start by presenting Ron Hunter on my team. He is the latest member to join the team. I assume he's standing up back there, way in the back. Say hi. He's doing much better, thank you. Ron comes to us from a variety of service roles within state government and municipal government. He has 26 years of accounting and purchasing experience. We are thrilled to have him help us lead the effort for moving from our current system onto the state CAPS system, which is the accounting system for financials, and he is leading the charge on that. He has got experience project management. He has worked for large state agencies. He has managed teams and served on boards, and he's just a great guy. Thank you so much, and help me welcome again Ron Hunter. So I will be brief today with my reports. We gave an in-depth report yesterday on the year-end budget. Today I will provide with you the end-of-year September update. We have 2 reports for you. Here is the first one, the reconciled of actual expenditures at the end of September. This one shows all the accrual for the end of August. I have just been notified by staff we'll probably have a few more things trickle through, especially as we're updating our space and we're doing those bills that can come in for things that we have completed, such as the construction. The next report is the 1 month report, which is, again, a budget status report for just 1 month. You'll notice on the right-hand side up at the top that it shows you the percent that we would expect if we were to do it equally throughout the year, which would be 91.6%. You can see down that column of budget remaining with a percentage. If there's a variance by more than 20%, we will always give you an update per the budget policy. And that concludes for the budget status report. If you have no questions, I'll move on to the investment report. And I'm going to go back and read my notes. It's a little bit easier. The first investment report for our operating account shows that we have one Treasury note that matured and was reinvested. This report also shows a running total of cash and reserves at a point in time, with the ending balance of the reserves at $11,224,546. The next investment report is for the Real Estate Recovery Fund, which we discussed yesterday. The payments that have been made, as you'll see on this next page, shows the payments broken down. Here we go. And this report, as you can see, shows how the payments that were made, and the great report that Kristen gave yesterday explained how the money gets into the account and how the money goes out from the account. And I thought that was very informative for me. I hope it was helpful for you. You'll notice on the next report, which is the Inspector Recovery Fund, we're required to remit balances, as Kristen mentioned yesterday, of over $600,000. This is the account where that's more likely to happen as opposed to the Real Estate and Broker Recovery Fund. This one is more likely to have that, and right now we've got an excess of $20,000. It'll likely be more than that by the end because we still have 3 months within the calendar year. So in January, we will remit everything over $600,000 into general revenue. And then finally, I have an update on the Public Finance Investment Act. And you'll notice at the bottom of this form there are 3 signatures. And that is me and my staff. We are the investment officers of the agency, although the trust reconciliation, the trust TTSTC, the State Treasury Trust Company, does all of our investments for us per statute for the SDSI status that we have. We are required by law, and I'm required to report to you that we have received the requisite training. Staff gets training every 2 years, and that includes executive director. And then all commission members are required to get training when they come on, and we file that in our files for you, and we will make sure that all new members have received that we've completed it, as we will be audited on that, as we're required to be audited every 2 years. I'm happy to answer any questions.
Any questions? All right. Thank you very much.
Thank you.
Okay, agenda item number 7, we'll do some committee reports. Executive Committee, I will report that the TREC Executive Committee, along with the TLCB Executive Committee, did meet to conduct executive director search and interviews, and there will be more information on that later in the meeting. Agenda item number 8, Commissioner Williams on budget.
Yes, I will report that we did meet and approve the 2020 budget. We have not met since then, but we will meet again before the February meeting.
Okay, Commissioner Turner on enforcement.
Enforcement Committee had a pretty light quarter. We did approve one motion for rehearing without a meeting, and we did that by telephone, which was nice. So that's all I have to report right now.
Very good. Broker Lawyer Committee, General Counsel Chelsea Buckholtz.
Good morning. Chelsea Buckholtz reporting on behalf of the Broker Lawyer Committee, which met on October 25th. And they considered the many comments that were submitted in response to the proposed amendments to the forms that you proposed in the August meeting. The decision was made to recommend a withdrawal of all of the proposed amendments to the forms with 2 exceptions. And you will have that before you in agenda item 25. So we'll talk about that more then. But I did want to report that 2 work groups were formed to address some of the issues that were raised in the comments. One work group will spend some time looking at the seller disclosure paragraph that is in the unimproved property, the farm and ranch, and the new home contract forms. And then there is a separate work group that has been formed in order to review the proposed paragraph that is in all contracts concerning leases. And then the committee also reconsidered their recommendation to strike the phrase specifying the payment of a fee between brokers. Instead of the current language, they have looked into amending that, and that language is included on page 54 of your materials. It's not before you today, but it raised enough concern that I wanted you to know the direction that they're headed. And with that, I'm happy to answer any questions.
Any questions?
Is there a general explanation as to wholesale abandonment of the previously proposed amendments to the forms?
Only that they wanted to spend more time digging into some of the details to make sure they get it right. They're on the lease paragraph, for instance, each of the contracts could address different types of leases, and so they wanted to spend some time looking at each one individually rather than putting the same language in all of them. So it was more of a time issue than anything else.
Any other questions? Okay, before you step down, report by Education Standards Advisory Committee is next. I do not see Rob Cook. Would you or Jennifer, who would like to deliver this?
I can do that. On the fly, I can tell you that they have met, and they also have some significant work group work going on. There is nothing before you today to consider that was recommended by ESAC, though I do expect that at the next commission meeting, they are looking into, they did make a recommendation to include 3 hours of contracts for continuing education, but did not decide whether or not to do that in 3 additional hours or within the current 18. And so it's being sent back to them for their recommendation on one or the other. And so I expect to see that and a few other recommendations at the February meeting.
Okay, any questions on that? Okay, thank you. And for those keeping score at home, that is agenda item number 12, and that is in your packet, the full minutes with talking about the contracts. Talking about the 3 hours additional. And also, Texas Real Estate Inspector Committee, Lee Warren.
Good morning. The agenda from the IAC will be light today. You'll see a modification to the consumer protection notice on your agenda. This has arisen to address the issue of limits of liability for inspections. We felt that modifying this notice served as the best way to notify the consumer about the statutory requirement for inspectors to carry liability insurance. Though inspectors may limit their liability in their own inspection agreement with their client, this limit may not infringe upon the statutory requirement that an inspector must carry liability insurance to protect consumers from violations of Subchapter G. We've also been working for some time on completely restructuring the pre-licensure process for becoming an inspector. Based on the Sunset Review and a number of variables that we have wanted to change for some time now, this package was put together. We've reduced the number of education hours needed by about half, all while focusing the hours needed to be a much more practical nature. This new pre-licensure process should not only make it easier for someone to obtain a license, but it should also make them better prepared to perform inspections for the consumer once they are licensed. During this process, we have received a lot of positive feedback from inspectors that have been licensed for years and ones that have been licensed just recently. We did receive public comment from one person on this stating a number of reasons that they felt this should not be done. We have taken these comments into consideration the multiple times that he has brought them up, and we have discussed them in great detail. Even considering this feedback, the IAC has voted unanimously on multiple occasions to this new pre-licensure process. However, apparently this has been pulled from your agenda for this meeting to give the governor's office a time to go over it. The Governor's Office sent out a directive regarding occupational license reform recently. Though we feel that we are accomplishing the best process for everyone involved while being in line with the Governor's directive, there is one education provider that wishes to delay the process. Though the points that have been brought up have already been disproven multiple times, we must now wait for this to go through the Governor's Office for review. Hopefully this can move forward quickly and we can put this process in place to provide the industry and consumers with a better quality inspector from the point of licensure. So,
Okay, thank you. Any questions?
Comment, Mr. Chair.
Yes, Commissioner Stevens.
Mr. Warren, I noticed your shirt, and you list your name and TREC and the number, and I commend you for being brave and for showing the way to others to act with transparency. Thank you.
Thank you.
Okay. Now I think we have some public comments. Henry Brett, agenda item 13, with Champions Real Estate. We will limit you to 3 minutes. Will that be enough time?
Oh, yeah,
Okay.
absolutely. Thank you for allowing me the opportunity to speak, ladies and gentlemen. I just wanted to, first and foremost, thank you guys for the opportunity to be in your workshop yesterday. I know it was very informative for us, and I got a lot out of it. But to the matter at hand, we wanted to speak today to Champion School of Real Estate position on the subject of increasing the continuing education hours. It is our firm position that the hours not be increased. We feel like Texas is a leader in this area as it stands now. We instead fully support the addition of 3 mandatory hours of content regarding contracts, as we know this is very relevant to the industry right now and highly in demand by your constituency. We feel that the addition of 3 hours adds an undue burden on both providers and people seeking their continuing education, and not just a financial burden to providers, which is then of course passed down to our customers, but the logistical burden of on both providers and people seeking their continuing education. This would by default extend a continuing education course to a 3rd day to be manageable for both providers and licensees. So that's our position as Champion School of Real Estate, and we hope that you will consider that. Thank you very much.
Okay. Any questions? Henry, 1 second. I think we have a question from Commissioner Turner.
I just want to make sure, can you give me cliff notes or bullet points or what have you on, I mean, I heard you say that it would place a burden on the providers as well as your students. And so I find your position curious, and so I want to understand it more, because as a provider, generally, wouldn't you benefit from providing more education, which is your business? So the more education you provide, the more money you make after you've paid your employees that provide that education. So I think we should pay attention to the fact that they're here almost against your own pecuniary interests. So can you explain just a little bit more for me, or just really be concise with the reasons why?
Absolutely. I completely understand your question, because it is a curious position, I think, for any provider to be in favor of keeping education at the level that it's at rather than increase. Our position is that, first and foremost, the logistical burden of a 3rd day is unseemly for anybody involved in this scenario. You're talking about 21 hours, and yes, we can teach a 12-hour day. I would challenge anyone on this body to find someone who wants to attend a 3rd day of Seee. So not only are we doing a disservice to our customer by not supporting keeping that load as minimal as possible when we already exceed the majority of the country as far as Seee requirements is concerned. Moreover, that burden on us as a provider, especially if we use a traveling instructor. Say we send an instructor to a different city to teach that Seee course. And yes, we do have the opportunity to use a local instructor, but many of our best instructors travel around because they are in demand. And that additional cost burden of that 3rd day, that eventually is going to fall on the licensee themselves when they take their Seee. So that's the logic behind our position.
Do you know generally what the delta is between Texas CE requirements and other states? I'm sure other states vary, but can you give me a general number? Because I don't have that information.
My understanding is that there is only one state in the country that exceeds Texas CE requirements, and I believe that is Nevada. We still maintain the highest hour requirement for CE aside from them.
Any idea what the average of those that are below us is?
It's anywhere from 15 to the 18 mark.
Okay. Thank you.
Mm-hmm.
Okay, any other questions? Okay, thank you very much.
Thank you. Comment, Mr. Chair.
One more, hold on.
I appreciate
We're not going to ask till you start leaving. Okay.
I appreciate you coming over and letting us know the concerns and explaining the way that you did. Thank you.
Thank you, Commissioners.
I was going to see if you turned around before you got back there. Okay, we have one more public comment. Kimberly? Oh, no comment. Okay. All right. Okay. You don't.
Commissioners, good morning.
Morning.
My name's John Lewis, license 149119, 50 years licensed here in the state of Texas. I've been in the Austin commercial real estate business that entire time. I'm wondering how much longer I have to take these tests. I mean, he's talking about the added 3 hours. I'm not getting much out of the first 18. It's something that I endure to keep my license, but I'd be better served if someone could send out, like TREC sends out notices each month of stuff, if they sent out stuff that would tell me of any legislative laws that have been passed, any changes, any court cases that would affect things. I've long since stopped using TREC forms and everything. I deal strictly with attorneys. I only have 2 or 3 clients that I represent at this point in my career, but I work full time on my own stuff. But I was wondering, I haven't been able to find any exemption application for TREC. Is there one?
No.
The similarities with the insurance industry and the insurance licenses are they're dealing with the same clients and public and everything. I'm looking here at an application they've got that says, my signature below certifies that I've been licensed by the TDI for at least 20 continuous years with no gaps in licensure greater than 90 days. I've never had a complaint against me. I've never filed a complaint against anybody. And I've been doing it 50 years, not 20. At what point do I not have to take this test that's not helping me?
Okay.
Do you have any suggestions, Mr. Lewis, on how we can continue to do our duty to protect the public and ensure that our practitioners are up to date on their knowledge other than requiring CE, even if someone at your advanced tenure?
If I thought I was getting anything out of this, or my clients were getting anything out, or the public was getting anything out of me continuing to do this, I'd be the first to want to continue to do it. But I think I'm better served, like I said, getting information which makes it me smarter in this industry, that y'all send me and I could read monthly, rather than taking time to do this test, which isn't germane to my business at all. Not at all. It's apples and oranges. So I would say pick a date. Somebody's been in the business 30 years. They ought to know their business. Pay your fee, annual fee, but then educate yourself monthly when you get notices. I just think it'd be in the best interest of the public and certainly for brokers like me.
Mr. Oldmixon or whomever, do we offer any CE credit for licensees who serve as instructors?
We actually have that rule proposed. We do.
That's something our friends at the bar offer, which I think, I'm presuming you'd be interested in teaching a course, but it's certainly something that as lawyers we can take advantage of, and we've been practicing for a while. We can get some credit for showing up and teaching classes because you're at a spot where you know everything, but you have a lot of colleagues who don't. But and that's not to say I don't appreciate what you're saying.
I don't have enough time in the day now and everything. That's why I'm here complaining.
Well, and that's why we're here too. So I appreciate you bringing that to our attention. You're not the first person.
Very much.
You're not the first person to bring that up to me.
Hope y'all can do something about this.
All righty.
Thanks.
Thank you, Mr. Lewis. We're going to skip through some agenda items and not go into executive session for probably about another 45 minutes to an hour. We're going to try to get as much done before then. So I am going to skip to agenda item number 17.
So, Chelsea Buckholz, General Counsel. At the August meeting, you had a large number of rules on the agenda for proposal. And so today, you have a large number of rules for possible adoption. So here we go. Agenda item 17. The proposed amendments were published in the August 30th, 2019 issue of the Texas Register. It's 535.101 and 535.210, both fee rules, and 534.2, processing fees for dishonored payments. That is proposed for repeal. The amendments to the two fee rules, 535.101 and .210, eliminate fees to license holders to implement statutory changes enacted by the 86th legislature in Senate Bill 624 as part of the sunset review process. Specifically, the fees eliminated eliminate the branch office license fee because the branch office license is eliminated. It also does the same with the instructor license fee because that license is eliminated. And it also streamlines and simplifies many of the additional fees. It eliminates the fee to establish, for example, it eliminates the fee to establish or change a relationship with a sponsoring broker in 535.101, and the fee for changing a license holder's name or to establish a relationship with a sponsoring professional inspector in 535.210. The amendments also add provisions to add the process for a follow-up payment after a dishonored payment, which is currently addressed in the rule proposed for repeal. And then similarly, the language in 534.2 is up for repeal because it was added to both of the fee rules. So as such, the staff recommends that the commission authorize staff to submit for adoption amendments to rules 535.101, 535.210, and the repeal of 534.2, as published to the Texas Register, along with any technical or non-substantive changes required for adoption.
Okay.
Move that the commission approve the staff's recommendations.
Second.
Motion made by Commissioner Leonard, seconded by Commissioner Turner. All in favor?
Aye. Aye.
All opposed? Any abstentions? Motion carries. Agenda item number 18.
Okay, agenda item 18 is the discussion and possible action to implement legislative changes enacted in Senate Bill 1200 regarding military applicants and license holders and adopt amendments and a new rule to 22 TAC 535.51, 535.58, that's the new one, and 535.208. The amendments to 535.51 and 535.208 removes licensing provisions related to military service members, veterans, and military spouses to consolidate special provisions for those individuals into the new 535.58. The amendments also eliminate the Texas residency requirement for inspector and real estate license eligibility pursuant to the statutory changes in Senate Bill 624, part of sunset. The new rule, 535.58, was added to implement Senate Bill 1200 to allow military spouses with a license in another state or territory to practice in Texas if the license in the other jurisdiction is substantially equivalent. The rule also provides clarity to license requirements related to military service members, veterans, and military spouses by consolidating into a separate rule. We did receive a few comments, mainly questions, and there was a request to clarify what was intended by the word veteran, suggesting that possibly referencing an honorable discharge or something other than a dishonorable discharge. However, we're mirroring the statute definition for purposes of really cleanliness. So the staff recommends that the commission authorize staff to submit for adoption amendments to 535.51, the new 535.58, and 535.20 as published to the Texas Register, along with any technical or non-substantive changes required for adoption.
Okay. Do I have a motion?
Move that the commission
We have a motion.
approve the staff's recommendation.
Do we have a second?
You have a question?
I have a question.
Yes, question.
I have a motion by Commissioner Leonard, second by Commissioner Wilkinson. I have discussion, Commissioner Stevens.
General Counsel, how are we justifying including the competence in the geographic market when a member of the military comes into the state of Texas?
How are we justifying their competency?
Yes.
I'll give you two answers. The first one is that they will be required to keep their education up, but also their license must be, they will be sponsored by a broker, unless they are a broker, and their license must be the substantially equivalent. For brokers and sales agents, there is no state with a substantially equivalent license. For inspectors, once and if pre-qualifying courses are modified for inspectors, that might come into play. But it's a reasonable question. Have I missed the boat on that, Mr. Olmixon?
No, but one of the things, because we don't have a direct substantially equivalent state, in almost every case, the requirement has been put on the individual to take the Texas real estate brokerage law, the current legal update, and pass the state portion of the exam. So those things are helpful just so that they feel competent, that they understand, we feel confident that they understand the Texas requirements. Now, working geographic competence, of course, if they're working under a broker, is something that the broker should require and have standards for. If they are a broker, then the same way that we enforce all of our requirements is, if there is a complaint that in fact someone is working outside their area of expertise. There's a legal requirement for them to work only within their expertise, and so we investigate complaints if they're outside of their expertise. Does that help?
Yes, it does. I have a further question.
Yes, Commissioner Stevens.
So if the member of the military who's transferring to the state of Texas is a broker, then the decision will fall solely on the broker to decide whether or not he or she has competence. Am I understanding that correctly?
That's right. And then on the back end, of course, this is reactionary. If that is not in fact the case, that would be dealt with through a complaint and an enforcement action.
But how do we, further question, so how do we keep the public informed of their rights in the event that occurs? Just so that when we have our rules, that we have the same rule for people who live in the state of Texas and those who are coming from out of state, and we all have to comply with the same requirements. That's the spirit of these questions.
Sure. One of the requirements for agents and brokers is to provide their clients with a consumer information page. That's not the right. Is that the right? And that includes the complaint process. So they are obligated to inform their client of how to complain.
I have a suggestion that perhaps on the information about broker services that we include something related the next time that the broker lawyer committee meets, that we include something related to this, so that we also let the public know that they also have a way to inform the commission in the event that that occurs.
That's a great suggestion. That's a great idea. In fact, that form is going to be before you later in the agenda today, not with that modification, but that's a great, I'll take note of that.
Thank you.
Okay, any other questions? Oh, we had a motion second. All in favor?
Aye.
All opposed? Any abstaining? Opposed. One. Commissioner Miller opposed. Motion carries. Agenda item number 19.
Okay, you should have in front of you a revised agenda item 19. Looks like this. It has a staple in it. It's a couple pages long. That was given to you on the dais this morning. So, this is discussion and possible action to implement legislative changes enacted in Senate Bill 624, eliminating branch office and instructor licenses and adopting amendments and repeal to 6 different rules: 535.57, 0.60, 0.67, 0.70, 0.72, and 0.112. Senate Bill 624 requires the elimination of branch office and instructor licenses. So these amendments make changes to account for that requirement throughout the 6 rules. We did notice late, and that's why it's coming to you as a revised version, the need to make one additional change, and it is on your second page and it's highlighted. To Rule 535.67, there's a non-substantive change. In subpart A.1.2, an audit report indicating noncompliance with the Act or rules is treated as a written complaint against the, should say, approved provider, not an accredited provider. We have not used the language accredited provider in many years, and this is simply just a clarifying amendment to account for our current practice, which we approve providers. As such, the staff recommends that the Commission authorize staff to submit for adoption amendments to 22 TAC 535.57, 535.60, 535.67, 535.70, and 535.72, and the repeal of 535.112 as presented to the Texas Register, along with any technical or non-substantive changes required for adoption.
Okay, can I have a motion and a second before discussion?
Mr. Chair, I move that the Commission approve staff's recommendation along with the non-substantive change in our supplemental materials to Section 535.67A2.
Okay, I have a motion by Commissioner
Second.
Turner.
Any other non-substantive changes?
Second by Commissioner Leonard. Any discussion? Seeing none, all in favor?
Aye.
All opposed? Anybody abstaining? Motion carries. Thank you. We will now go to agenda item number 20, Kristen Werman, Deputy General Counsel. We'll have the next 3 or 4 agenda items.
Good morning, Chairman and Commissioners. In agenda item 20 is discussion and possible action to implement legislative changes enacted in Senate Bill 37 that eliminates consideration of student loan defaults, and Senate Bill 624, our sunset review legislation that authorized the denial of a license renewal if a license holder is in violation of a commission order. The rules before you in this agenda item are Rule 535.61, 535.62, 535.71, 535.73, 535.91, 535.403, and 543.12. The amendments to 53561. Also change subsequent approval to renewal and authorize the Commission to deny an application for renewal as an approved provider if the provider is in violation of a Commission order, consistent with the legislation. The amendments to 535.62 authorize the Commission to deny an application for renewal on the same grounds. The amendments to 535.71 change subsequent approval to renewal and authorize the Commission to deny an application for renewal if the provider is in violation of a Commission order. The amendments to Section 535.73 reorganize this section for clarity and clarify the process for renewing approval of an elective continuing education course. Amendments to this section also authorize the Commission to deny an application for renewal of an elective continuing education course approval if the provider is in violation of a Commission order. The amendments to Section 535.91 remove consideration of a student loan default when deciding whether to grant an occupational license and authorize the Commission to deny a license renewal if the license holder is in violation of the terms of a Commission order. Amendments to this section also correct a grammatical error. The amendments to Section 535.403 implement statutory changes in Senate Bill 624 and authorize the Commission to deny a license renewal if the license holder is in violation of the terms of a Commission order, as do the amendments to Section 543.12. No comments were received on the proposed amendments to any of these sections. Staff recommends that the Commission authorize staff on behalf of the Commission to submit for adoption amendments to 22 Texas Administrative Code, Section 535.61, approval of providers of qualifying courses, Section 535.62, approval of qualifying courses, Section 535.71, approval of Seee providers, Section 535.73, approval of elective continuing education courses, Section 535.91, renewal of a real estate license, Section 535.403, renewal of registration, and Section 543.12, renewal of registration, as published to the Texas Register, along with any technical or non-substantive changes required for adoption.
We'll take a motion.
Move that the Commission approve the staff's recommendations.
I have a motion from Commissioner Leonard. Second. A second from Commissioner Miller. Any discussion? Seeing none, all in favor?
Aye.
All opposed? Any abstaining? Motion carries. Agenda item number 21.
Before the Commission today in this agenda item is the discussion and possible action to implement legislative changes enacted in Senate Bill 624 applicable to complaints filed on or after September 1st, 2019, and adopt amendments to 22 Texas Administrative Code, Section 535.191, Schedule of Administrative Penalties, and Section 535.219, Schedule of Administrative Penalties. The proposed amendments to these two rules were published in the August 30th, 2019 issue of the Texas Register and implement the statutory changes enacted in Senate Bill 624. Essentially, the bill renumbered the statute that describes the violations of the Real Estate Licensing Act, and these amendments implement the changes by renumbering the provisions in the Commission's rules. No comments were received on the proposed amendments. Staff recommends that the Commission authorize staff to submit for adoption amendments to 22 Texas Administrative Code, Section 535.191, Schedule of Administrative Penalties, and Section 535.219, Schedule of Administrative Penalties as published, to the Texas Register, along with any technical or non-substantive changes required for adoption.
Let's seek a motion. Agenda item 21.
I move that the commission approves the staff's recommendation.
Second.
Second.
Got a motion by and a second. All in favor?
Aye.
Aye.
All opposed? Any abstaining? Motion carries. Motion by Wilkinson, second by Leonard. Agenda item 22.
Before the commission in agenda item 22 is a discussion and possible action to adopt amendments to 22 Texas Administrative Code, Section 535.41, Section 535.52, Section 535.142, and Section 535.400. These amendments implement legislative changes enacted in Senate Bill 624 regarding public comments, removal of the term moral character, dismissal of complaints, and the elimination of residency requirements. The amendments to Section 535.41 clarify the Commission's policy for allowing public comment at regular quarterly meetings, such as the meeting we're having today. The amendments to Section 535.52 change the language in the caption and throughout the rule from moral character to fitness. The amendments to Section 535.142 direct the Commission to dismiss a complaint if the complaint is inappropriate or without merit, and to protect the complainant's identity by excluding identifying information from a complaint notice sent to a respondent. The amendments also reorganize this section and group all grounds for dismissal of a complaint in subsection D. The amendments to Section 535.400 remove the residency requirement for becoming registered as an easement or right-of-way agent. There was one comment received regarding proposed amendments to Section 535.52 relating to the change of the term moral character to fitness. Staff recommends no changes because doing so would contradict the statutory changes made by the 86th legislature. That comment is before you at page 221 of your materials. Staff is recommending that the Commission authorize staff to submit for adoption amendments to 22 Texas Administrative Code, Section 535.41, Procedures, Section 535.52, Moral Character Requirements for Individual Applicant, Section 535.142, Consumer Complaint Processing, and Section 535.400, Registration of Easement or Right-of-Way Agents, as published to the Texas Register, along with any technical or non-substantive changes required for adoption.
Would seek a motion.
I move that the commission approve staff's recommendation.
A motion from Commissioner Miller. A second. A second from Commissioner Stevens. Any discussion?
I do have a question.
Sure.
Commissioner Leonard.
As we're trying to exclude any identifying information from the complainant, at what point do we disclose who the complainant is? Is it only in the initial complaint, or is it throughout the process?
With the changes under this rule, it is only in the initial complaint notice that is sent to the respondent to let the respondent know that a complaint has been filed.
So as things proceed, that person's name who we are keeping confidential on the initial complaint will be disclosed?
Yes, that is our expectation, and may in fact be aware to the respondent based on the allegations in the complaint itself.
Okay. Mark, anything you would need to add?
Clarify that a bit, if I may.
You may.
Yeah, and Ms. Warman was exactly right on what she said. I just want to clarify, it's a very limited situation. It would be like perhaps an advertising complaint or pointing out that someone has a criminal record. In most cases, because the law says to the extent possible, so in most cases it can't really apply. So it's a pretty narrow exception on that. So it's not, and the law still prohibits anonymous complaints. So it is exactly as she said, it's in the initial complaint notice.
Okay. Commissioner Turner.
I just have a comment. I understand this was a legislative mandate, but I have due process concerns as well with licensees' ability to confront complainants. I'm glad that we're handling this the way that we are. I'm not sure what the impetus was for making this directive from our friends at the legislature. So I suppose I'll be voting under protest, but I'm glad that our licensees will be provided with the opportunity to confront their accuser at the appropriate time. Thanks.
Okay.
Well, and Commissioner Turner, just to let you know, this directive came from the Sunset Commission staff. This is one of their recommendations for all occupational licensing agencies. And as it was explained to us, it was to encourage the filing of complaints by consumers. That said, staff was also concerned and raised the due process issue that you mentioned with the Sunset Commission and the staff, as well as in our response to the directives that they presented to the legislature. So we are aware of that, and that's partly why, as Mr. Moore pointed out, we are complying with the statutory change, and we fully anticipate and expect that license holders will be made aware of who is complaining against them throughout the process.
Yes, ma'am. I recall those discussions and your efforts, and I appreciate them. I think I was part of those discussions. So I'm just putting it on record during our public hearing today that I thought this was somewhat misguided.
May I second what Commissioner Turner said?
Okay. Any other comments? All right, all in favor?
Aye.
All opposed? Any abstain? And I know we had two in opposite. Under protest. The motion carries. All right, agenda item 23.
Before the Commission today, and agenda item 23 is discussion and possible action to implement or to adopt amendments to section 535.402, complaints, disciplinary actions, and appeals, section 539.150, complaints, and section 543.5 violations. The amendments to these three rules would align the response times in these rules with other TREC rules and change the response time from 10 working days to 14 days or 14 calendar days to provide greater clarity to respondents and consistency within the TREC rules. No comments were received on the amendments as published, and staff recommends the Commission authorize staff to submit for adoption amendments to 22 Texas Administrative Code Section 535.402, complaints, disciplinary actions, and appeals, Section 539.150, complaints, and Section 543.5, violations, as published to the Texas Register, along with any technical or non-substantive changes required for adoption.
Okay. Seek a motion?
Sorry, no. Well, I've got a question, so I'll wait for that portion.
Okay, can I have a motion?
Move that the Commission approve staff's recommendation.
Motion made by Commissioner Leonard, a second.
Second.
Seconded by Commissioner Wilkinson. Discussion, Commissioner Turner.
Thank you. Forgive me for my hot mic today. I've got a lot of questions. So I appreciate what we're doing, and I just have one question. How do we handle, as we move from business days to calendar days, how do we handle, or do we have a rule that addresses when a calendar day deadline falls on a weekend or federal or state holiday.
That's. Want to address that, Mr. Moore?
Remember the video?
It's not extended any. Our analysis was that 14 calendar days ended up being about 10 working days. And in the real estate business, every day is a working day. So that's where we fell on it.
Would we accept something that we are requiring of applicants or license holders that are under disciplinary proceedings if they send it to us on a Saturday?
Yes, absolutely.
Or
Yeah, but the
Sunday?
fact most send them by emails now too, so that's another thing where it's pretty much 24 hours a day.
Perfect. Just making sure you know where I'm coming from.
Absolutely.
Thinking about rules of civil procedure, and I just want to make sure we're allowing for that, because that's one trap for the unwary if you move from business days to calendar days. So as long as we're accepting things every day. All right, perfect. Thank you.
Any other questions, discussion? All in favor?
Aye.
All opposed? Anybody abstaining? Motion carries. Thank you. Agenda item 24, General Counsel Chelsea Buckholz.
Chairman, I'm happy to make comments to explain these rules. However, I only if you want to spend the time on that instead of going straight to the request to postpone. Sorry, I should have said this before. I did receive one email comment today from Stan Harbuck asking that that his email be included in his comments, which are included in this agenda item, simply notifying the Commission that the Governor's Office has established the Licensing and Regulatory Review Office, and he requests that these rules be submitted to that office for review.
And we are in the process of submitting that, so I guess protocol would be a motion to postpone, motion to pull, or just what's...
There's no action necessary on this item at all.
Well, then let's go to agenda item number 25.
Okay. So just for clarity, agenda item 24 that is being postponed is 535.209, .212, .213, and .214 related to the education of inspectors. Okay. Moving to agenda item 25. This is the discussion and possible action to adopt amendments to 22 TAC Chapter 535 regarding the standard contract forms. The proposed amendments were published in the August 30th, 2019 issue of the Texas Register. The Broker Lawyer Committee considered all of the comments received since the contract changes were proposed. The committee recommends withdrawing all of the amendments along with the forms adopted by reference, with the exception of 535.47 regarding the third-party financing addendum and 535.55 regarding the addendum for authorizing hydrostatic testing. The third-party financing addendum adopted by reference is amended to clarify that the 3-day notice requirement in paragraph 2B does not apply to paragraph 4, and the time is of the essence language was moved to the body of paragraph 2 for clarity. The addendum for authorizing hydrostatic testing adopted by reference in 537.55 is amended to include a reference to the scope of hydrostatic testing in the first sentence. There were 8 commenters that submitted comments on the proposed amendments to the third-party financing addendum. After some discussion, the Broker Lawyer Committee declined changes in that addendum. They recommended adoption of the amendments in both 537.47 and 537.55, and the forms adopted by reference as proposed. Staff recommends the Commission authorize staff to withdraw amendments to 22 TAC Chapter 537 and the forms adopted by reference as presented, and to submit for adoption amendments to 22 TAC 537.57, Standard Contract Form TREC number 40-8, Third-Party Financing Addendum, and 537.55, the Standard Contract Form TREC number 48-0, the Addendum for Authorizing Hydrostatic Testing. and the forms adopted by reference as published to the Texas Register, along with any technical or non-substantive changes required for adoption with an effective date of March 1, 2020.
Would seek a motion?
I move that the commission approve staff's recommendation.
Motion made by Commissioner Miller,
Second.
second by Commissioner Wilkinson. Any discussion? All in favor?
Aye.
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 All opposed? Anybody abstaining? Motion carries. We will go to agenda item number 26. I do have an additional public comment we will get to as soon as General Counsel finishes the next 3 or 4 agenda items. Then we will get to the public comments. Agenda item 26.
Okay, this is the discussion and possible action to propose amendments to 531.18, the consumer information. This proposed amendment in the form adopted by reference was recommended by the Real Estate Inspector Committee. The proposed amendment to the Consumer Protection Notice adds a statement to alert consumers that inspectors licensed by TREC are required to maintain errors and omissions insurance to cover losses arising from the performance of real estate inspection in a negligent or incompetent manner. Real estate license holders are required to post this notice at their place of business and on their website. Staff recommends the Commission authorize staff to submit the proposed amendments to 531.18 consumer information in the form adopted by reference as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Okay.
I move that we adopt this amendment as proposed by staff.
Motion made by Commissioner Stevens, second by Commissioner Leonard. All in favor?
Aye.
Discussion.
I'm sorry, discussion. I'm sorry, Commissioner Turner.
I would like to place at whatever appropriate time or in our collective consciousness a question to the Commission. In reviewing this rule or proposed rule change, it's come to my attention that, and inspectors aren't alone in doing this, but that many inspectors in the inspector community are putting a provision in their contracts which limits their liability, potential liability to the consumer to the cost of the contract, the fee that was received. Some people may think that's fair. Some people may think that's unfair. Some people may think that parties are free to contract however they see fit. I see other professions doing this in my practice. I see engineers in particular, architects. The reason it draws my attention and why I think we should probably talk about it, with all due respect to our friends in the Inspector Committee, I want you guys to limit your liability if you can. And I'm not even sure if this is in our purview, but I've seen situations where, to use an example from the engineering community, where an engineer's professional negligence has undisputably caused the owner of some property that was engineered improperly to incur hundreds of thousands of dollars in damages in the form of repairs to that property or loss of use or something like that. And that engineer carries professional negligence or errors and omissions insurance that is well in excess of those damages, $1 million policies typically, like other professions carry. But the Texas courts uphold limitations on liability in contracts like those that are tied to the price of the contract.
Mm-hmm.
I personally question whether that's good public policy, in particular when we require our inspectors to carry liability insurance that would cover damages far in excess if they were liable for something, which it's pretty hard to get to inspectors too, I can tell you, that damages that were in excess of the cost of that contract, which can sometimes just be a few $100s. And again, I don't know whether it's our purview to step in there or not, but I think it merits some discussion at some other point. So Ms. Buchholz, if you could just note maybe for one of our future, maybe for our inspector committee meetings, I'm happy to come and sit down and talk to them about it, or for our future workshops, I think it's something we ought to have an eye on.
No, thank you. Note taken. Yes.
Absolutely.
And
Chair, I have additional comments.
yes, Commissioner Stevens.
Going along the comments of Commissioner Turner, perhaps we should consider the Texas courts honor freedom of contract, and so should we. But I think that so that we can also provide protection to the public, that perhaps the inspectors, as they are providing the information to the consumer, that they should have a disclosure that is signed, just like information about brokerage services, prior to servicing, and something that with a notice that is conspicuous that to the consumer in Texas that shows, for your information, please review this agreement, because we believe, Texas honors freedom of contract, but this agreement that you may be signing might limit your liability, and you may not be able to obtain any more relief than the amount that you're paying, and the costs that you may be facing would be a lot larger than that. So I think that way we can balance out freedom of contract and protection of the public. Perhaps that's a consideration.
Well, and it might be a consideration with this same notice that we're proposing here, that notice say, however, please note that the inspector's liability on this agreement may be significantly limited to by the contract to be including under, because I think this is a good, I think you guys mean well. I'm speaking to our inspector committee representative when you want to disclose that you're required to tell the consumer that you carry errors and omissions insurance, but that 50 cents in that will get you a Coke if you've elsewhere limited in the contract your liability to the cost of the contract. So there is some it could be misleading there. If I'm a consumer and I'm a layperson and I'm going through a contract and I see, oh, well, this is great. It says here that they're required to carry up to $100,000 in insurance. So I know if they miss something on this inspection and I've got to go back later and hold them accountable for that they've got at least $100K in insurance, and then 2 pages over it says this contract's limited, your damages are limited to, I mean, it's not a conflict. Well, I don't know that they're incongruous.
You've identified the tension both of you have between the need to protect the consumer and the freedom to contract. This is not a new issue for inspectors. It's one that is highly contentious. This proposed change to the form is seen as a step. Not that and really further examination is I know welcomed, but this has brought out inspectors in large numbers to voice concerns, but this is not the end of the story for sure.
Commissioner Stevens, and then Lee Warren, chair of the inspector committee, would also like to make a comment, but Commissioner Stevens?
This should not only apply to inspectors. I mean, with Commissioner Turner, it's a very important concern. I think that the problem is the agency cannot go out there and actually verify what inspectors are doing. They still must comply because it's the law and they have to follow it. The problem is that how will the agency find that out? And we should not just do it with inspectors. I mean, this also affects commercial real estate. Every transaction is usually a contract, and it is a contract that is designed just for that transaction, and we cannot, I mean, although they're sophisticated buyers, but I think as an agency, we could not take that responsibility because we just don't have the staff, so we need the help from the public,
I'm sorry, I don't understand what you mean. I asked for further clarification. I just don't understand your comment. I apologize.
I guess that I thought that you were saying that you're thinking about further protecting the public. Mm-hmm. Our job is to protect the public, but we also have limitations because we cannot control what inspectors who generally are going to be following the law, but there will be some who will not follow the law, just like not just inspectors, but any practitioner who is licensed by this agency. So it puts a limitation on the agency because it would be very difficult for us to be able to review every contract that goes out there. So perhaps it's disclosures, but it's very difficult to protect the public other than just give them information and perhaps have penalties if that occurs.
Well, a prohibition on limitations on liability would protect the public, and I think that would be within our power to promulgate a rule in that regard. Perhaps not.
Yeah, legislatively.
Okay, so that's a legislative change. So that's not us, and I appreciate that. But maybe to your point, I think Commissioner Stevens, that if we can make sure that the notices we're providing are adequate, we could require, for example, that contracts that have a limitation on liability, that language be conspicuous, all bold, all caps, within the first page, something like that, right? And leave it up to other crusaders to go try and remove that ability to have a provision like that in some other venue. It just I've seen it in real time play out in a way that's really messy. And I've got anecdotes if you want to hear them sometime.
Okay. Would ask Inspector Lee Warren, Chair of the Inspector Committee, comments?
This has been an ongoing issue for quite some time. We've been having this discussion for a couple of years now. Ms. Warman will certainly remember. We've kind of gone back and forth about this. The limits of liability, what typically happens, and the reason why a lot of these limits of liability are in there is due to frivolous lawsuits. There are a substantial number of people, especially in our industry, that as soon as something happens, we're the first person that they want to file that complaint. That we're the first person. Okay, you may think we're the second person, but trust me, in what we're discussing, we're almost always the first one that's there. And a lot of times it's things that we could have not possibly seen. And we did a lot of research on this previously to determine which cases have actually come forward, where people are actually trying to sue the inspector, whatnot. The vast majority were under $12,000. A very, very small portion were up to the 100, and I think only one or two of the insurance carriers that we talked to went over the $100,000 statutory requirement. So the purpose of this was because we don't feel that we as a committee or this entity should really get directly involved in the agreement between an inspector and their client. And the courts have, stated that the limits of liability can be there. The whole point in this, and what most inspectors do, is they have the client sign that agreement prior to the inspection actually happening anyway. So they have the opportunity to read through it and know what those limitations of liability are before they actually have the inspection performed and pay that money to that inspector. So if they want an inspector that doesn't have those limits of liability, they say, you know what, I see your agreement, great, I'm going to go on to the next person. And they are allowed, as a consumer, to make that choice. The purpose of this is to make sure that even if that limit of liability is in there, that a consumer has a means to know that there is a statutory requirement that they are protected against violations of subchapter G. In this case, regarding negligent and incompetent manner. Incompetency is really defined by the standards of practice in that subchapter, and that's what defines that. So this is our way to notify the consumer of, hey, there may be limits of liability, but it can't conflict with that state statute, that there is a state statute that requires every inspector to have errors and omissions insurance.
But the fact is that a limitation on liability in your contract, while it can't conflict with the requirement that you carry up to $100,000 or at least $100,000 in E&O insurance, it absolutely conflicts with the consumer's ability to collect damages that are within that range between your fee under the contract and the amount of insurance you're required to carry.
Well, private limited liability can't conflict with can't supersede state statute on the requirements to have E&O insurance.
I don't understand. One more time.
So if a consumer is under the impression, let's say an inspector violated subchapter G, which falls under that statutory issue as far as the limits of liability, and they try to sue said inspector, and the inspector says, sorry, I'm limited to only the cost of the inspection and whatnot. They can say that even though that may be the verbiage that's in there, but any lawyer that's going to take a look at that going, you can't have a private agreement between you two that's going to violate a state statute. I mean, that state statute's still going to prevail. that if there's a violation of subchapter G, that is still covered under that errors and omissions insurance or that liability insurance.
Is that what subchapter G says, or does subchapter G just require that inspectors carry a certain level of insurance?
No, subchapter G actually encompasses the standards of practice, everything that we're required to do, any departure provisions that are there. It basically is our protection. It states what an inspector is supposed to do during the process of an inspection, what they inspect, what they don't inspect. Departure provisions, protections, basically if something is behind the wall, we couldn't see it, we can't be held liable for that, those types of things. Subchapter G encompasses all of that in there.
Okay, but the statute that requires inspectors to carry a certain level of errors and omissions insurance, does it also mandate that inspectors can be liable for up to that minimum insurance requirement?
Yes, for violations of subchapter G. It specifically states that it's a protection of liability for violations of subchapter G.
Commissioner, so what this very, very long discussion, and I know the example that you used was potentially voluntary E&O insurance. In this case, it's mandatory E&O, so it may be distinguishable. There's not a court will end up deciding unless the legislature clarifies, because on its face, you have clearly identified there is a legal requirement. It is meant to protect consumers for any violation of subchapter G. That's what it says in the law. However, we have the general freedom of contract that the courts have acknowledged, and there's some case law around that. So the only thing that I would add is it'll either take clarification from the legislature to resolve the potential conflict, or a court to rule and then the legislature step in.
Well, and let me be clear, I represent a lot of professionals, and the first thing I put in their contracts is a limitation of liability, because they're enforceable. Yeah. And frankly, I disagree with you that a requirement that you carry a certain amount of liability insurance is clearly a requirement that you be also liable. Although that would be an argument for an enterprising lawyer to make. On the other side of that, I would say no. The courts have upheld limitations in liability. Just because we're required to carry up to $100K in insurance doesn't mean that if we contract for a limitation that's within that $100,000, that's what the parties have contracted for.
And
so
we've kind of looked at it because the statute specifically states the limits of liability are specifically for violations of subchapter G. Mm-hmm. And that's kind of, it wasn't just you have to carry liability insurance, end of story. It's specific. You have to carry liability insurance specifically for violations of subchapter G. So all that is pretty clearly defined. Okay. That's kind of how we're looking at it.
I'd also just offer that putting a limitation on liability is, I think there's some question academically as to whether or not that is an effective manner of curbing frivolous lawsuits, because by the time you get to liability, a lawsuit is anything but frivolous. It's actually been through the ringer, and by the time you have some damages that are limited by a limitation on liability, that's been vetted several times. So this is a personal axe I have to grind that we can take up later. I don't want to waste anybody else's
the
time.
amount of
this deserves some more thought.
The amount of lawsuits that I have seen that have absolutely been curbed by limits of liability are pretty substantial, not only from my own personal experience.
Here's an anecdote. I have one right now. I represent the owner of a daycare who had an engineer design an AC system for them that is entirely inadequate for that space. And the daycare was running at about 82 degrees this summer when it was hot. And it's going to cost $250,000 to replace that system with a system that's adequate. And the engineer's contract was limited in liability to the price of the contract, which was $3,700. Mm-hmm. So, and there's no question, zero question. I've had 3 other engineers look at the system, and it's an engineering deficiency. The engineer was negligent in the provision of their professional services, and that owner's going to have to eat whatever, $193,000 or $197,000.
Now, if there was a state statute that said if that inspector going in had to determine the efficiency of that unit and the liability because directly result of that, then we would run into an issue where I think Mr. Olmixon's correct. The court would have to decide. But, the presumption is that that state statute that tells you are liable for anything within that subchapter, regardless of any other limit of liability.
All right, I'm going to bring us back in one more.
I'm sorry.
No, you're fine. One more comment, Commissioner Stevens.
Just that even to the public, that even if one of those agreements were signed, the limitation of liability that is imposed by statute, it's going to be decided by a court. So it's not going to stop it because it likely cannot be waived. So just making the public aware.
And this is one step for us that we're trying to make the public more aware that inspectors are required to have that liability insurance.
Okay. I think it's been clearly noted that this is probably something we need to look at. What this motion is really concerning is it has been added to the Consumer Protection Bulletin that they must maintain E&O. And I think it's something we can definitely note to look at in the future, different liability. But I would entertain a vote on the motion that is before us, even though I think we've voted for discussion. All in favor? All in favor of the motion that puts it in the consumer information form?
Aye.
Aye. Aye.
All opposed?
Nay.
I've got motion passes. I've got 2 opposition, Commissioner Leonard and Commissioner Turner. Agenda item number 27.
Okay, this is discussion and possible action to propose amendments to Rule 535.154, the registration and use of alternate team and assumed business names used in advertisements. I think this is going to be the most contentious rule you see today, if I can be sarcastic for just a moment. We had a typo in this rule that included the words believe and think shouldn't be there. It should just be believe. And so this proposed amendment removes that unnecessary word that it was inadvertently left in the text during the last substantive change of the rule. So staff recommends the commission authorize staff to submit the proposed amendment to 535.154 as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
I move that this commission approves staff recommendation.
Second.
Motion moved by Commissioner Stevens, second by Commissioner Leonard. All in favor?
Aye.
All opposed?
Nay.
1 opposed. Opposition.
No. Sorry.
Motion carries. Okay, we're going to do agenda item 28. Then we're going to have the public comment, break for executive session. Then we will come back to agenda item number 29. So agenda item number 28.
This is the discussion and possible action to propose amendments to 535.216, the renewal of a license. So this is the last proposed rule that we know of to implement law from the 86th legislative session. The substantive changes here mirror those presented for adoption in agenda item 20, though these are for inspectors. This eliminates the consideration of student loan defaults, and it authorizes the commission to deny license renewal if a license holder is in violation of the commission order. The proposed amendments also reorganize this section to improve readability and increase transparency for license holders and members of the public. The Texas Real Estate Inspector Committee recommends these proposed amendments. Staff recommends the commission authorize staff to submit the proposed amendments to 535.216, renewal of a license as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
I move that the commission approve staff's recommendation.
Motion made by Commissioner Miller.
Second.
Seconded by Commissioner Russell. Any discussion? Any discussion? All in favor?
Aye.
All opposed? Anybody abstaining? Motion carries. We're going to go back to agenda item number 13. We have a public comment from Craig Smasser. And Mr. Smasser, we will limit to 3 minutes.
Yes, sir.
And thank you for coming.
Yeah, well, Chairman Kessler, members of the Commission, thanks for reopening this. It seems that today's meeting has moved at a faster pace than ones in the past have. My name is Craig Smizer. I am the broker-owner of 1835 Realty. Last week, the National Association of Realtors voted to implement a policy known as Clear Cooperation to all realtor-owned MLS systems across the U.S. Set to take effect in May 2020, this policy is designed to restrict lawful advertising done by Texas real estate licensees, thus infringing on the purview of not just the Texas Real Estate Commission, but also the Texas Legislature. At issue is eliminating the use of coming soon marketing. While I understand a minority of real estate licensees may use this in an attempt to handle both sides of the transaction, the vast majority of licensees use it as an effective marketing tool for their clients to build anticipation in the marketplace and to gauge buyer interest while clients finish preparing their homes for the market. It does not seem appropriate that a Chicago-based trade organization can eliminate lawful advertising currently permitted here in Texas. If the Texas Legislature meant to prohibit this form of advertising, they would pass legislation to do so. NAR claims that this has no impact on real estate law because it only affects members of the MLS. I think that we all understand it is virtually impossible to be a successful real estate licensee on the residential side without access to the MLS, so this truly is a restraint of trade on Texas members. It is not just me who's against this policy. The boards of directors for both the Austin Board of Realtors and the Austin Central Texas Realty Information System sent an email to its membership on October 25th, encouraging members to voice opposition to NAR regarding this policy. I request that you take a look at this overreaching trade organization policy and take whatever action is necessary to ensure that Texas laws and TREC rules govern Texas licensees. Thank you.
Thank you for your comments. Commissioner Wilkinson.
You are right. I was in the on the board of directors for NAR, so probably since 2004, we had the largest audience ever at the NAR MLS meeting, and then at the board of directors, of course, it went on forever on this issue. And frankly, there's, either way you go, there's questions on the other side, fair housing issues, as you well know probably. So it is something that we are probably looking at the beginning rather than the end on. This is my personal opinion, but it's out there now and it's a step.
Okay. Commissioner Stevens.
Can you please give us an example of what they are attempting to do so that the members of the public actually understand this, and we all do, those present, because it's a fairly new rule that it's come up, but it's only coming up from NAR. So
sure.
Thank you.
Right now, for example, when I sign a listing agreement, the listing agreement may begin today, but it may not be slated to go into the MLS for 10 days so we can get professional photos taken, things like that. Seller can finish getting the house ready. We'll go ahead and usually in my firm, limit of about 10 days ahead of time, we'll put out a sign with a coming soon rider. And that would be prohibited now under this new NAR policy. There can be no advertising whatsoever unless the property is in the MLS. Again, ABOR and Actress here in Austin, both are against this policy, but they will not be able to, it's come down from NAR, from down above, up above.
Right, and it did come down, and there's going to be a lot of discussion over the next 4 or 5 months. So we appreciate you coming and bringing it to us. It has, I think all of us have probably received a text, email, or phone call concerning this. So it is something that's definitely on our radar that we do realize could be a concern.
One other point. 97% of the NAR directors across the board voted for this, as you well know. And it's something that we just have to look at. And believe me, there's issues on both sides. I sat there as a board director, and I think a lot of others, I can see both sides of this issue, and I think that's where we're at now, and there'll be lots of discussion.
I guess I come from the standpoint of it can be a local issue, right? You know, Austin might feel one way, Houston another, but in my opinion, I don't like the concept that what is permitted by law as advertising by the Texas legislature is going to be removed by a trade organization, limiting, you know, my ability to advertise what is in the best interest of my client.
Okay, thank you very much. Okay, it is now 12:10. We are going into executive session. I think we'll be in executive session for approximately 1 hour.
I didn't think it would wind up on our day.
Okay, it is now 1:42. We are back in session. I will apologize for running long. I did learn that if I call an hour and a half, we cannot come back in early. So I called an hour, and so we're late. So I will excuse me for that. You just never know exactly how long it's going to take. We're going to jump around on the agenda. I am going to agenda item number 15, the contested cases, and I'm going to pass the gavel to T.J. Turner, and he will take the gavel, agenda item number 15, and TJ, Mr. Castro is here.
Okay. Thank you, Mr. Chair. Ms. Horman.
Yes, Mr. Chair and Commissioners, before you in Agenda Item 15A is the proposal for decision in SOA docket number 329191295.rec in the matter of TREC versus Rogelio de Castro, and the proposal for decision recommends revocation and a $1,500 administrative penalty.
Well, I should know this by now, but do I call the respondent or staff first? Call staff first, right? Thank you. Mr. Moore.
Yeah, and all three cases today involve respondents, people with license holders, where we have the burden of proof on it.
Thank you.
This one, we do agree with the proposal decision and do recommend adoption on it. According to the opinion, the decision, the items that were in the record, Mr. Castro had a scheme to steal money from bank customers, and he had an accomplice who was a Wells Fargo employee and committed theft by withdrawing funds from 3 separate accounts. He did have an attorney. They're both here today to speak with y'all as well. Do y'all have any questions for me or for Sandy Zimmerman, who was the lawyer on the case?
Commissioners, any questions at this time for our staff? Okay. Mr. Castro or Mr. Montes? Yes, sir. That's fine. I'm going to limit you to 3 to 5 minutes, okay? So
I appreciate that. And I'll have some brief remarks, and then he'd like to address you all.
Sure.
We appreciate the time you all given us to talk with you all today. We're not here to ask for anything but to give Mr. Castro a chance to continue working as a realtor. We understand the findings and the conclusions of law. We also understand that you all have the discretion to perhaps allow probated revocation or probated suspension as the disciplinary action in this case, although we understand that the administrative law judge did propose revocation. I would just point to the record briefly by stating that Mr. Castro committed this crime in 2015. He was convicted in 2016, but in the time since the conviction has been employed steadily with the same realty company, has the full support of his broker who testified on his behalf at the administrative hearing, along with associates, and I think most importantly an actual client who testified on his behalf to indicate that that he's been nothing but honest and trustworthy, at least with him. And generally speaking, I can say that and he will address you all, address this fact with you all, but he is one of the top agents at his company. He is just here to ask for a second chance of some sort so that he can continue on with his livelihood. With that, I will pass it on to Mr. Castro, who will address you all. Thank you.
Good afternoon. My name is Rogelio Castro. Thank you for allowing me to be here and speak on my behalf and plead for my livelihood. Kind of nervous, but I just I look back. I just can see myself as a lost soul. I can go back and wish I can apologize to the victims involved, but I have to live with it every day. I'm on probation. I've met all my requirements and continuing to do so and bettering myself from then until now. It's just to be a better person and do my fiduciary duties as an agent and act in the best interest of my clients. And I feel like I've done so with being an agent. And I am the top agent in my company, 50 agents. I'm the best agent there to my broker, and I try to do the best I can for them. I can't take back what I've done, and that's something that I have to live with, but I just ask for a second chance to be able to continue to work. And like I was given a second chance to be on probation and be out here freely, just a second chance to continue to work under any stipulation y'all have, or under anything, under any circumstance or whatever y'all have. I'll do it as long as I can continue to work. Thank you very much.
Commissioners, anyone have any questions right now for Mr. Castro or his attorney? I have one question, Mr. Montez or Mr. Castro, if you want to answer. Do you have a specific proposal for us? I mean, I heard Mr. Castro say he'll do whatever, but right now the ALJ's recommended revocation. Is there some other action that you think would be more appropriate, and if so, why?
I can answer that, just because what I've been asking for since the beginning of the case before we went to the hearing was any kind of probated. I know you all have done a probated revocation in instances, probated suspension, anything that obviously he understands what he can't change the facts of what he did. But if you all need to keep the closest eye scrutiny on him, he's willing to do anything as long as he can continue working. And I've discussed this with him. He wants to be a realtor. So if he can't be a realtor, revocation is the most. I mean, it's the death sentence, right? So if he's able to come back, if you all don't want to probate a revocation, I did speak with him, and he's even willing to do some kind of enforced suspension if you want him to do anything in the meantime to prove that he's honest and trustworthy in order to keep his license in some form or fashion. But he would like to continue working. Again, his broker is completely behind him as far as the job that he's doing, and that her testimony was in the record. So. Thank you.
Thank you. Any other questions, Commissioners? Commissioner Stevens?
Mr. Castro, there were funds that were withdrawn. Did you return the funds?
Yes, I have restitution fees that I pay for every month to give back what was taken from them, and in all the terms that was given to me, I've met them all. But paying back the restitution fees every month. I haven't paid them all in full because they set them up to where at the end of my 7 years that they gave me, I will be finished paying that off.
Thank you.
And if I just may add really quickly, so this may have been brought up, but as far as the restitution, if he could pay it all right now, he would. It's just he's on this schedule, so it's by no means that he's doing it monthly to withhold any kind of restitution. That's just the payment plan that's in place.
Commissioners, any other questions? Okay, thank you. Sit tight. We may call you back up. Mr. Moore, do you have a response?
As the judge noted and heard all this evidence, this was a very serious crime. He's a top agent, one of the best in his profession, and has not paid back that. So there's a disconnect, I think, sometimes on these sort of issues. Again, our recommendation is revocation and the penalty, which is what the judge recommended.
Any questions for staff? Okay. Any more questions for Mr. Castro or Mr. Montez? All right, at this time, I'll entertain a motion.
I move that we adopt the proposal for decision as modified by the ALJ, including finding of fact 18A.
I have a motion. Do I have a second?
Second.
Second by Chair Kestner. All those in favor of the motion, please say aye.
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 Any opposed, say nay. Nay. Motion carries. Thank you, gentlemen, for being here. All right, at this time, I will call agenda item 15B. Ms. Foreman.
Commissioners, before you in agenda item 15B is consideration of the proposal for decision in the matter of SOA docket number 329185257 REC TREC versus Amy Chen. In this case, the ALJ has recommended revocation of the license and a $27,000 administrative penalty.
Mr. Moore.
Yeah, this was one of the really bad ones where we had this scheme with repeated victims who were promised money or had money taken from them. So we do think revocation and the penalty is appropriate. We did want to point out one typographical error. On page 119, the conclusion of Law 8 referred to 2 violations. It was actually 3 violations. All the monetary amounts are correct. It's just clearly a typographical error, and page 115 of the same PFD actually had it correct in there. So we're just offering to correct that. I'm available for any questions, as well as the lawyer on the case, Mogi Lavelle.
Okay.
We do not think they're present, but
Is Ms. Chen here, or anyone on her behalf? Okay. Commissioners, do you have any questions for Mr. Moore? Hearing none, I'll entertain a motion.
I move that we would exercise the authority under Government Code number 2001.058E. 3, to modify conclusion of Law 8 and correct a typographical error in the first bullet point and adopt the proposal for the decision as it has been modified.
I have a motion. Do I have a second?
Second.
Any discussion? All right. All those in favor of the motion, please say aye.
Aye.
Any opposed? Moving on, agenda item 15C. Sorry, motion carries on 15B.
Commissioners, before you in agenda item 15C is consideration of the proposal for decision in the matter of SOA docket number 329191490 REC TREC versus Arnulfo Silas III. The ALJ in this particular matter is recommending a 5-year probated suspension of the license.
Mr. Moore.
on this case, we didn't have any issues with the findings of fact or conclusions of law. We thought it was a well-written opinion, a well-reasoned opinion. We did disagree with the recommendation, and as we discussed yesterday, the staff makes a recommendation, judge makes a recommendation, y'all get to decide. So you can go with the 5 years probated suspension, which the judge argued for, and again, it is supported by facts and law. We do think a revocation is supported by facts and law because there were 5 crimes, including the recent insurance fraud, as well as 2 previous agreed orders. One was including dishonest conduct, and one was an advertising violation. So when he was a broker, or as a broker, he had 2 previous violations. So this would essentially be an 8th chance. So that's why we made that recommendation. The commission also has the option of downtime as well. So y'all have all these options before you on how you wish to proceed on that. I'm available to answer any questions. We don't think.
Can you tell me why we didn't file any exceptions?
Yeah, we didn't disagree with any of the conclusions of law or findings of fact. We thought it was a well-written opinion. We would just disagree with the recommendation, so we'd just be going before him making the same arguments we made. So there's nothing new to add. So we think that's more just what the commission's function is to decide on a recommendation.
Do we need to find something to disagree with in the findings of fact or conclusions of law to justify substituting our own judgment for the administrative law judges?
Yeah, you're not really necessarily substituting, and I don't think you're necessarily substituting your own judgment. You're just fulfilling your duties as a commissioner, since you get to make the final order or the final decision on this. So I think it's just right in your core duties, and y'all have been doing this for years on this. It's conclusion of law 8. That is a recommendation. Sometimes they put it in the conclusions of law. Sometimes they break it out in the recommendations. So you do have to explain why you're doing that, and it's supported by, without changing any of the findings of fact. They support any of those options, and I think what the judge wrote was well reasoned as well. Yeah.
Any other commissioners have questions for Mr. Moore?
I move to adopt the proposal.
Oh, hang on just a moment, please. Commissioner Miller, is it Mr. Sellis here or anyone on his behalf? Okay. At this point, no questions for Mr. Moore. I'll entertain a motion.
Now I move to adopt the proposal for decision as written.
I have a motion. Do I have a second?
Second.
Is there any discussion? Okay. All those in favor of the motion, please say aye.
Aye.
Any opposed, say nay. Motion carries. Mr. Chair, am I presiding over 16 as well?
You may. Yes.
Okay, thank you. Agenda item 16.
Commissioners, before you in agenda item 16 is the discussion and possible action to authorize settlement of a recovery fund matter RF 19005, Teresa Whitaker versus Carlos Hernandez and Dickie Green.
Okay. Commissioners, anybody have any questions for our staff regarding agenda item 16? Hearing none, I'll entertain a motion.
Moved. We recommend move that we authorize settlement payment of $8,055 in actual damages plus interest and court costs.
I have a motion. Do I have a second?
Second.
I have a second. Is there any discussion? All those in favor of the motion, please say aye.
Aye.
Any opposed? Motion carries. Mr. Chair.
Thank you, Commissioner Turner. We will go to agenda item number 29 concerning the criminal offense guidelines. And Commissioners, there was a separate handout on this.
Chelsea Buckholtz, General Counsel. There is a separate handout with a revised agenda item 29. It is just front and back. The proposed amendment to 541.1 implements statutory changes enacted by the 86th Legislature in House Bill 1342 regarding the requirements for evaluating the criminal history of licensed applicants and license holders. After considering the factors identified by the legislature in House Bill 1342, the proposed amendments revise the list of criminal offenses considered directly related to the duties and responsibilities of the licensed occupations under the jurisdiction of TREC. You have a revised rule before you, and that's based on the work that you did yesterday at the commission workshop. Specifically for inspectors and easement or right-of-way agents, this rule removes the felony DWI or DUI from the list considered directly related, since these license holders are not responsible for driving clients. So as you will see in this amended rule, subsection A it will remain in effect for brokers and real estate sales agents, and will keep the felonies involving driving while intoxicated or driving under the influence. That's subsection 15. But a new subpart B is added that is a duplicate of A, but without that DUI and DWI, and that is for inspectors and easement or right-of-way agents. I'm going to walk through the remainder of the sections just so that you know exactly what this rule is doing and that you're comfortable with these proposed changes. In section C, A fifth factor was added to determine whether an offense is directly related to the license. That's number 5, C5, any correlation between the elements of the crime and the duties and responsibilities of the licensed occupation. This mirrors the legislation. In Section D, we removed details of the types of recommendation letters that will be used to determine fitness. This also mirrors the legislation. In Section E, we clarified that it's the license holder's responsibility to provide those recommendation letters, again, mirroring the legislation. And finally, Section F clarifies that the Commission does not consider arrests that do not result in conviction or placement on deferred adjudication or community supervision in determining fitness. This is a long-held practice, but just simply to clarify in order to satisfy that bill. So with that in mind, the staff recommends that the Commission authorize staff to submit the proposed amendments to 541.1 criminal offense guidelines as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Move that the Commission approve staff's recommendation.
I have a motion by Commissioner Leonard.
Second.
Second by Commissioner Williams. Discussion? All in favor?
Aye.
Aye.
All opposed? Anybody abstain? Motion carries. We will now go to agenda item 30 under pending business. We have had a search committee for a new executive director, and the search committee was the executive committee of the commission, along with the chairman of the appraisal board. We had a number of applicants. The applicants were narrowed down to final interviews. The final interviews were conducted last week. All the commissioners were invited to attend, along with all the board members, and the board was engaged in the interview, even though the MOU says they do not have a vote. We wanted them to have a voice. And at this time, I would entertain a motion concerning the new executive director.
Mr. Chair, I move that this commission hire Chelsea Buckles as the TREC executive director to be effective January 1st of 2020.
I have a motion from Commissioner Stevens. Do I have a second?
Second.
I have a second from Commissioner Leonard. Any discussion? Seeing none, all in favor?
Aye.
Aye.
All opposed? Anybody abstain? Motion carries. Congratulations to our new executive director, Chelsea Buckholtz. With the motion establishing January 1st, we will ask staff to post, announce, expedite filling the position of general counsel. So that will be done. Okay. Agenda item number 31. That means we're getting close to the end. Okay. Pursuant to policy established in May of 2016 by the Commission at the last quarterly Commission meeting each calendar year, this meeting, the Commission will include an item on the agenda for nominations for the position of Vice Chair and Secretary. Additional nominations and a vote to elect a Vice Chair and Secretary from those nominated will occur at the Commission's meeting and the Commission's meeting in the February meeting. So basically, this is where the campaign season starts, I'm guessing, okay? So we can entertain nominations, but there also be nominations in February, okay? Do we have any nominations now? Wait till February? I mean, this is kind of a strange policy, but.
This is my opinion only, and that is that with the transition that's going on, that we have a little time to think through this process. and perhaps come back in February with recommendations.
And I'm fine with that. Okay, that concludes agenda item 31. Okay, agenda item 32, we have a deadline of December 1st to respond to the governor's letter concerning different aspects of the way the agency is ran. We vetted this in the workshop yesterday. I am going to very carefully approach this, that I want final approval of the final draft to be approved by the executive committee, but include everybody on the emails, wordsmithing, whatever, until then. Okay, we will include everybody, but the final draft will be executive committee to make that approval, not just the chair, with full vetting from all the commissioners. Commissioner Turner.
Staff recommendation was to delegate final approval of the response to you, Mr. Chair. And what I hear is you're suggesting something different than staff recommendation, which is that final authority over that and approval over that response be delegated to the executive committee, not just you, but with input from all the commissioners?
Yes, that is.
Okay. So I move that the commission approve staff's recommendation with the following changes. That final approval of the response to the October 8, 2019 letter from the governor be delegated to the executive committee following input from each member of the commission, and that the letter be submitted to the governor's office no later than December 1. Is that accurately?
That is accurate.
Okay, that's my motion.
Second.
We have a motion by Commissioner Turner, second by Commissioner Leonard. Further discussion?
Would you restate? We didn't hear him.
I'm sorry. Was I mumbling? It's late in the day. This is when my Lubbock comes out and I start going like this.
Sorry.
The staff's recommendation was to delegate final approval of the letter to our chair. Our chair has suggested that final approval be delegated instead to the executive committee with and following input from each member of the commission. So I move that the commission adopt the staff's recommendation, but with the following changes: that the final approval of the response to the letter be delegated to the executive committee rather than solely to the chair, and only after input from those of us on the commission that are interested in providing our input.
Thank you.
Yes, ma'am.
I did want to clarify two things. The first is that we will email that draft to all members of the commission, and I would ask that you email your response without hitting reply all, so that we don't have any sort of deliberations occurring in a closed forum, but that you would be able to incorporate your opinions that then the executive committee could review. Also, just to mention that today is Tuesday, we have the remainder of this week, a short week next week, Thanksgiving holiday, and then it is December 1st. So the staff will act very quickly to get a draft to you so that you have an opportunity to provide your second round of input.
Okay, any further discussion? All in favor?
Aye.
All opposed? Nobody abstaining? Motion carries. Agenda item 33, discussion and possible action regarding future agenda items. Anything on the agenda for the future? Yes, Commissioner Stevens.
I would like to, on behalf of Commissioner Hargraves, so he suggests that we schedule the following commission meetings for the remainder of the year to try to make every one of these for everybody's long-term planning.
Yes, ma'am. If there's nothing else on 33, we'll go to 34, and it's talking about scheduled future meetings. We had our first workshop yesterday. We're talking about a budget workshop in February. We're talking about commission meetings. We're wanting to do, or the chair is wanting, more workshops, more engagement. We're going to work to try to get them all scheduled for 2020 before January 1st. That way, if at all possible, you have as much time as possible to mark those out. And I know life happens and things happen, but we're going to do our utmost. I've already talked to Chelsea about it, and the executive about, getting as many dates scheduled as we can early. That way we know. Because the more engaged we are, the more vetting, the better decisions we make. And I think that was evident at that workshop yesterday, just how much stuff we really got done. The interaction between us and the staff was just, I think it was a win-win for everybody. So we will definitely work on those dates for everybody. Because I realize, and I told this to Executive Director Olmixon,
Thanks.
We need to appreciate the public members on this agency. We're all realtors, we're brokers, and when I leave, we still have people making money in my office, I hope. I'm hoping they're making money. These public members, they take vacation time, sick time, not billing time. It is a huge commitment to them. And I think as an agency, we can certainly do our best to schedule these ahead of time, not only for us, but also for the public members. So I value everybody's time, and so we will definitely work on that.
I just have one quick comment. First of all, thank you. As a public member, I appreciate that. But everybody's time is equally valuable. And as I point out as often as I can, I usually walk or scoot to these meetings. I'm right around the corner. You guys travel from as far-flung destinations as El Paso. So I think we all appreciate everybody's time, Chair Kestner. This has nothing to do with an agenda item, but I did want to just take this opportunity in the agenda to point out the fact that the search for the new executive director, the time leading up to that, the search committee, the interviews, so forth. I thank you, Scott. You really have done a fabulous job. For those of you that weren't privy to what was going on behind the scenes, Chair Kestner he kept us all with our nose to the grindstone. First of all, he made this happen quickly and efficiently. We had a tremendous amount of help from our staff. As always, you guys made this so much easier in terms of providing questionnaires, organizing our meetings, herding cats to get us all here, Kristen. I really want to commend everybody involved in that process. We had a lot of really great candidates. It was a hard decision. It was made easier by the fact that it was well organized and the fact that we had some outstanding leadership driving the process. So I just want to take the opportunity to say thank you to the staff, thank you to everybody that participated, and thank you to the chair for really a tremendous job in working through that.
And we second that. Yes.
And let's, Kristen and Tony keeping us on task and emails at midnight with everything. It was an entire effort by everybody. With that, I would love to entertain a motion to adjourn at 2.
Future meeting. You got to talk about future meetings.
Oh, future meetings. We have the 2 scheduled.
Right. February and May.
I did announce it. Yeah. Okay. We have 2 meetings scheduled, February 10th, and looking at budget workshop on the 11th, and then February 11th for the budget workshop, and then May 4th for the commission meeting, and possibly a workshop after that, and then August 10th for a commission meeting. We will get this transcribed to an email with everybody and work on some more dates. Okay. Yeah. I mentioned earlier we are directing the staff to get the general counsel posting out there. You can tell all of us we are ready to move forward. Okay. Now I would love at 2:16 to entertain a motion to adjourn.
So moved.
I don't know who moved or seconded. All in favor? Aye. All opposed? Nobody abstaining? Adjourned.